The following presentation is entitled Pennsylvania, New Jersey Concurrent or Co-Ownership of Marital Estate, the Tenancy by the Entirety in Bankruptcy by President Christina Grappo. In this presentation, I compare Pennsylvania law with New Jersey law in bankruptcy court inside of the tenancy by the entirety conversation. The Pennsylvania dispute summary of facts is the Third Circuit in Nepontic versus Equibank and Parkville Savings Association in the Third District expressly ruled that a tenancy by the entirety exemption claimed under Pennsylvania law was exempt from process because creditors of either spouse cannot acquire by judgment an enforceable lien on entirety property or title therein by sale or execution. The Third Circuit further stated that this aspect of Pennsylvania's entirety common law was the chief distinguishing characteristic of an estate by the entirety and therefore exempts it from the ordinary legal process to which all other estates are subject. New Jersey summary of facts include the Entireties Act greatly expanded the protections afforded to the entireties property in New Jersey as in Pennsylvania. It does not preclude a creditor from executing under the property when the title was deeded as a fraudulent conveyance by one spouse to the other in entirety form so that the conveyance spouse can avoid his or her known debts. In contrast to Pennsylvania's relatively straightforward and somewhat generous rule allowing a tenancy by the entirety exemption under 522b3b as provided by the Third Circuit, there is no Third Circuit precedent interpreting New Jersey's exemption statute. Bankruptcy courts in New Jersey have applied a much more stringent standard to determine whether the New Jersey exemption statute is subject to process. The tenancy by entirety, the concurrent estate at play as identified in the article Tenancy by the Entirety Exemption and what it means to be exempt from the process includes the definition of the tenancy by the entirety is a marital estate shaped by spouses who share the right of survivorship. Pennsylvania and New Jersey from the article are two states of the 21 states that recognize the tenancy of the entirety, which arises in any conveyance to married couples. As a marital interest, the tenancy by the entirety protects married couples from certain types of creditors and unilateral conveyance. Creditors of one spouse cannot touch the tenancy. If one spouse transfers his or her interest to someone else without the approval of the other spouse, the new person receives nothing due to unilateral conveyance of one tenant being a nullity. Pursuant to 522b3b, a debtor may exempt any interest in property in which the debtor had immediately before the commencement of the case an interest as at the tenancy by the entirety to the extent that such interest as a tenant by the entirety is exempt from process from applicable non-bankruptcy law. Neither spouse may destroy the tenancy or alienate any portion of it for his or her exclusive benefit without the approval of the other. The concurrent estate of tenancy by the entirety in light of the suite's concentration with the conclusion including victorious party is the following. While the federal homestead exemption code is fairly frank in allowing a debtor to exempt up to the amount of $24,925 in home equity under 522d1 and d5, the same truth is not possible for a debtor's ability to exempt real property owned with his or her spouse using a tenancy by the entirety exemption under applicable state laws provided under 522b3b. Pursuant to 522b3b, an insolvent borrower may exempt any interest in estate property in which the debtor had immediately before the beginning of the case, an interest as a tenant by the entirety, to the degree that such interest as a tenant by the entirety is exempt from process under non-bankruptcy law. Further, neither spouse may wreck the tenancy or push away any portion of it for his or her exclusive benefit without the approval of the other. Additionally, property that is owned by the entirety is not owned in their individual ability, but rather owned by a marital unit. Property owned as a tenancy by the entirety is comprised of the right of survivorship. When one spouse dies, the surviving spouse becomes the individual sole owner. In Pennsylvania, a creditor of only one spouse cannot levy on property owned by both partners as tenants by the entirety because the marital unit is not the true obligor. Creditors may reach entirety's property to placate the shared debts of the spouses, though. A husband and wife who own property together as tenants by the entirety and are liable on a given debt may favor a judgment for the creditor in attempting to collect such an estate. The appellate level of courts ought to resolve Pennsylvania and New Jersey issues regarding what makes entirety's property subject to process because both jurisdictions are within the Third Circuit. The outlook for the losing party to motion or disallow a tenancy by the entirety exemption should address stark ruptures in authority by appealing to the Third Circuit of Appeals under the Bankruptcy Abuse Prevention and Consumers Protection Act of 2005. Applying to this directly has the stipulation from 28 U.S.C. 158D that would likely grant the debtor's ability to safeguard their home from the reach of creditors, which is a topic of public importance to ensure a standard circuit-wide rule of what establishes being exempt from process really means. And the following is my bibliography. This concludes my presentation.